Hi, I'm Trisha Dunlap with Dunlap Law, PLC, a small business law firm in Richmond, Virginia. We help business leaders thrive. And I'm here today to talk with you about COVID-19 and discrimination in the workplace. As a business owner, I imagine that you have worked long and hard to create a productive, inclusive, and empowering culture for your employees. It's really important as we come back to work after the COVID-19 crisis that COVID-19 not disrupt or undermine the culture that you've created. It's also important to consider potential legal liabilities around discrimination claims if you don't have carefully thought out policies and procedures related to how your business manages employees in weeks to come. So let's talk briefly about EEOC guidance on how employers can interact with employees related to COVID-19. First of all, the EEOC tells us that it's perfectly appropriate for business owners to ask their employees about their COVID-19 symptoms. In fact, you should have a written policy for your employees that informs them of their duty to report to you if they're feeling sick, or if someone they live with is sick, or if they've been in close contact with someone who's been diagnosed with COVID-19. Secondly, EEOC guidelines tell us that you can implement a temperature testing protocol for your employees. You should, however, think through some of the downstream impacts of this, such as when and how you're going to test your employees. Will they be on the clock or off the clock? Will they be in the building, or will you do the tests outside the building before they enter? So there's a lot to think through on that, but it is okay for you to require temperature testing of your employees. Third, it's also okay to test your employees for COVID-19 or to require that they be tested under certain circumstances. You need to think that through, and again, it should be part of your written policies. You should ask employees who believe they are in a higher risk category to inform you of that. And then you should work with that employee to create a reasonable accommodation that will hopefully accommodate their needs as a higher risk individual and also still perform the essential functions of their job. Two things you should not do under any circumstances. Number one, do not single out an employee unless you have a reasonable belief based on objective evidence that that employee may have COVID-19. Secondly, under no circumstances should you ever identify an employee by name in connection with their health status to other employees. So whether or not one employee has COVID or doesn't have COVID, it's nobody's business in the workplace. You should never identify that employee by name, regardless of whether the health status is positive or negative. That could be a violation of HIPAA. So with all of this in mind, this is a beginning point for you to think about potential discrimination issues around COVID-19 in your workplace. I hope this video has been helpful. On our website, Dunlap Law PLC, we have a whole page devoted to COVID-19 resources, from videos to webinars, blog posts, and articles. I hope you'll check that out. We've made it all free because we're hoping to be helpful. If you've liked this video, please let us know. Hit that like button, share it, and subscribe. I'm going to have a bunch more videos coming out, at least one per week, and we hope that this has been helpful to you. From Dunlap Law in Richmond, Virginia, thanks. I hope you're well. Bye.